to Access to Justice. I'm your host, Heather Malarick of Merrick Law. I'm joined today by my co-host, Evan Clark of Kahane Law. Hey, Evan, how are you doing?
I'm good, Heather. It feels like it's been forever since we've done this because the last episode you and Kim did without me. And I don't know, when was the last time we did it before that? Like over a month or something. We've been on summer holidays.
We have. It's been nice out. I've been enjoying the time away from the office and the camera, but it's nice to be back and see you as well.
Yeah, I've had fun too. It's been a little bit too nice for many parts of the world, like the dead bodies showing up in Lake Mead and the warning stones in Europe, like, hey, if you see me, start crying because you're going to die.
Oh dear. I've also been taking a break from the news, so I have not been listening to that, but that's not good. I guess we don't need more reminders of our changing climate, hey?
Well, I don't know, like, okay, so we got a drought going on, but these rocks are from like the 1600s, so it's not the first time. But yeah, drought time. But it's been great in Edmonton.
Sure has. It really has. Yeah. We're also joined today by Kim McDonald of McDonald Advisory. Kim's a financial advisor and insurance advisor with Raymond James Limited. Hi, Kim. How are you?
Hi, Heather. I'm amazing. I have some special news.
I think I know what it's going to be. What is it?
I got my braces off after like 2.5, I think almost 2.5, closer to 3 years. So I don't I on our previous episodes, when I watched them, I have such a hard time like keeping my mouth closed because my braces didn't fit in my mouth. So now I can just close my mouth without trying.
So do your teeth feel super smooth?
Everybody keeps saying that. Yeah. Like, it's just like, it's a wiggly little situation in there now. It's it's very smooth. It's a great feeling.
Nice. Congratulations.
Thank you.
Yeah. Congratulations. That's amazing.
Is that a new printer?
No. That's braces is the only thing new around here. So
okay. I just don't remember seeing that there before.
Well, maybe listeners will have to comment if they can hear the lack of braces in Kim's voice.
Yeah, you sound smoother, Kim.
Thank you, Evan. I appreciate that.
Well, without further ado, I'm going to introduce today's special guest. Today, we're going to take a bit of a deeper dive into collaborative law, and I'm very pleased to announce that we have Jeff Johnson here to join us. Hi, Jeff. How are you doing?
Hi, Heather. I'm doing great. Thanks for having me. This is exciting to be a part of. So,
well, we're really excited to have you here. I'll do a little intro of you first. You're a lawyer at Court, Stults and Johnson in Sherwood Park. I've also gleaned from your bio that you are an educator, a musician, a parent, and a martial artist. And one thing that I picked out that I really liked about in your bio was you say that in your lawyer role, you help clients in crisis regain their footing and move forward. And I really liked that. So welcome. We're so excited to have you here and to hear how clients can move forward, I guess, smoothly and perhaps using the collaborative practice.
yeah, exactly. I mean, I think that's always been the most rewarding part of a file for me is when a client says, you know what, you helped me through this really difficult thing, and I like the way you guided the process, right? And it's like, okay, that was now rewarding as opposed to, here's an amount of money in a bank account or whatever it is that might be the practical or the tangible end results. Well, thank you for that introduction. I was going to tell Kim, I went to the dentist this morning too. But
I haven't gone in too long. I need to do it again.
So I just recommend don't go because it just seems to be bad news. The older you get, the more it's bad news.
Jeff, you guys got to update your webpage. I just pulled it up and I just see Court and Stults.
it is the worst webpage on the internet. So I'm going for the prize. I'm just going to keep it up there until we.
First of all, that's not true. Your text is not blue on a gray background.
Okay, well, I thought I was on my way to a prize, so thanks for ruining it. Now I guess we have to just update it with actual information. Yeah. No, the website is ancient and largely unhelpful. So I promise I'll update it sometime.
Okay.
That's my commitment to myself, I guess.
Well, it's recorded now.
Jeff, you have an interesting, as I recall, I don't recall exactly your background, but I remember when I first met you, your background was interesting in terms of like switching to fully focus on collaborative law. And I can't remember what your evolution was in law, but am I right? Is it a little bit interesting?
I don't know. I don't know that I can speak to what's interesting about my background, but maybe so. My background in law, it might make my clients feel better, or maybe not. I don't know. I got into law fairly late. I think I went to law school as, I guess I was early 30s, which is a little later than the norm. I finished law school and said, I started practicing in a very small firm doing family law, and quickly learned that I didn't want to do it. In fact, I was quite convinced I didn't want to be a lawyer. So I left, and I went and did a bunch of other things for about 5 years, including I worked in the restaurant industry, had a couple of experiments that basically crashed and burned, which was pretty fun. Continued on in a music career that had been going well before I ever went to law school. And then ended up doing regulatory law. Well, I wasn't working as a lawyer. I did regulatory advising at ATCO in environmental regulations, and then got back into law, like I said, 5 years later at another firm here in Sherwood Park, and ended up practicing mostly employment law for, I don't know, 4 years or so, 4 or 5 years. And the suggestion was made to me that returning to family law, basically with the sole purpose of practicing collaborative law, might be a good fit for me. And I think part of it was that opportunity to work with a client and really dig into what it is that makes them tick, what it is that really matters to them, what those elements that have to get in place in order for them to get back up on their feet. That opportunity to engage on that level is appealing to me. I guess that means I'm not really, I don't know. I find the black and white of litigation can be a little bit discouraging for myself. And engaging a client on this kind of level, and working with their counterpart, the opposing party, as we like to say, in a way that doesn't dehumanize them. And this is not, I'm not trying to jab at litigation, although I usually tell my clients I'm pretty biased. But being able to treat, my lawyer counterpart and the other spouse or the other party on the other side of the table, with something other than doubt and I don't know, other negative things. More curiosity, I guess. That was appealing to me. So.
Well, so Jeff, I can confirm Kim's suspicions. That was very interesting, and I like your timing. Maybe I'm biased because I graduated from law school at 36 or 35, so it's a good time. That's a good time to go to law school. About 10 years after everyone else.
Yeah, it's good times, right? So
before we get into talking more about collaborative law, you got to tell us a little bit more about your music career.
Oh, okay. Well, I think my music career can be summed up by saying I'm a terrible businessman when it comes to music. I think hopefully I'm doing better with law, but that might not be true. I grew up in a very musical house. Started piano when I was 3. Moved on to bass, electric bass, acoustic bass when I was a teenager, and kind of from there I started playing professionally in Edmonton and around the province when I was 17, I think. And that was like the sole purpose of my life, it's just to play music and to specifically play the bass. Got my undergrad degree, taught music, taught bass at Grant MacEwan for about 15 years, or MacEwan University as it's now called.
Yeah, but back then it was a premier music college called Grant MacEwan.
Yeah, I think it had a good reputation way back in the 70s and 80s. Grant MacEwan was the place to study music in Canada. So we had some unbelievable, Canadian celebrities that lived in your center here in Edmonton, and they have quite a legacy. They're mostly gone now, unfortunately. So.
Yeah, I wasn't saying that tongue in cheek. I remember I played jazz band in high school, and I remember, seeing them at all the jazz festivals and stuff, and trying to recruit musicians and stuff.
Yeah, of course. Yeah. It was a big effort there, and it was a good place to be. It was a good place to learn, good place to teach. So, so music career wise, I did that. I taught. I played around town. I played around the province. I toured Canada, mostly doing jazz and other kind of freelance work. Whatever walks through the door. Want to play polkas? Okay, we'll play polkas. And do classical music? Yeah, that's great. Or funk, jazz, rock, all that kind of stuff. So it took a long time for me to identify myself as a lawyer as opposed to a musician. And sometimes I kind of regret that change still. So.
You can be both, can't you?
I hope so. I still play, still do some stuff. So
good.
Not as much as I might like, but it's all I have time for. So
nice.
I think Evan also, I don't want to identify you as anything, Evan, that you're not comfortable with, but I think you also identify as a musician. Is that?
Yeah, I do. Much less successful musician than Jeff. And he's even saying he's not successful. So what does that say about my music career? Terrible. But, yeah, I've played a lot of music over the years, and it's not about being a good business person in music, Jeff. It's almost impossible to make any kind of a decent living in music in Canada, in general, and especially in Canada.
This is true. But I admire the guys who don't give up. They just keep on.
Yeah. Like the guys like Sloan who are like in their 50s and they're just still just playing those clubs all across Canada.
Yeah. must be tiring though. Must be tiring. What's your instrument, Evan?
The main one's guitar, but I play a little bit of bass. I'm sure I would not compare it to your chops, but it's a natural crossover from guitar. I play a little bit of drums as well, and I sing.
Excellent. It's a good mix there. So,
in fact, the music that brings in and exits our podcast are from my releases. So
excellent.
Yeah.
What else?
Nobody knew that until this moment.
I didn't know that, and I'm going to pay special attention now. So,
okay, so that's. I think having a varied background helps in unexpected ways in law. Like, there's no way you would just say, okay, traveling the country as a touring bassist and teaching at MacEwan and doing all these things. You wouldn't just say, oh yeah, so obviously you'll be a good lawyer. But I do not doubt that your experiences from doing that inform your practice of law in ways that you don't even notice.
Yes, I'm not going to deny that. I think that all of the varied backgrounds that we all bring give us an ability to relate to our clients in ways that's irreplaceable, right? So nothing to knock our younger colleagues who move straight through the system and get right into practice without any other kind of intervening careers or experiences. But certainly as we get older and wiser, our ability to relate to our clients a little better is irreplaceable. So sure.
Yeah.
So collaborative law is how they roped you back into family.
I guess so, yeah.
I don't know what that says about your employment practices. Like, hey, Jeff, I really think you would like collaborative family law.
Probably it stemmed from the habit, I guess, of I don't know. I was never much of a litigator. never much, very reticent to go to a courtroom. I think I had I don't know if it was self-serving or client-serving. I really don't know the answer to that. Maybe it's both, but I always felt that going to court on the employment matters was kind of a failure to adequately communicate with the other lawyer, and to prepare my client for what to expect. So I think I was showing that tendency already. So collaborative law was obviously like natural. You don't go to court. It's like, oh, well, this is clearly practice for me. So not that court isn't the right place for a lot of different things. And even in family law, there's some very valuable things that happen in the courtroom. But for the I don't know if, I hope it doesn't sound insulting, but to say the average client, the average dispute here, or problem to solve, the average dissolution of a relationship, so my clinical way of looking at it, I guess, that courtroom experience, I didn't see it as being the best way to go.
Yeah. So if you could eliminate all the communication failures out of the family law court system, it would be a much shorter list at the courthouse. I think it's safe to say that.
I was going to comment that, I think we've probably all had that experience of sitting in the courtroom and hearing a matter be called up before the judge, and one side doesn't know what the other side's position even is on the matter that's before the court. So when you mentioned that, like, if you felt like if you ended up in court, it was because of a failure to communicate, I think that's an extreme example, but there are a couple of examples like that happening most mornings in the courtroom. So maybe now is a good time to like back up a wee bit and talk about what the collaborative process is and how it's different from court or similar to court. Would you mind giving us a bit of a Cole's notes on that, Jeff?
I can do my best, and you'll help me where I struggle. I'm sure where I hope. I mean, to break it down to its absolutely rudimentary practical level. And sometimes I describe this to clients this way, and sometimes not. But I mean, really, all collaborative law is that commitment not to go to court. So we won't use court. We'll do this by talking. But by taking court out of the equation, we force a different way of approaching the problem, because we don't have a hammer anymore. We don't have the ability to say, at least if we're respecting the process, we don't have the ability to say, well, fine. Well, if you don't like it, we'll find some other way to solve this problem, that being the judge. So if we're taking away the hammer, we need to be able to keep the conversation going at the table in a way that moves us. So, and I think if I'm not completely misapprehending how the function of collaborative law evolved, all of the principles that we kind of hold front and foremost in collaborative law stem from that need to push it forward without our hammer of court. And by that, I mean, we as collaborative lawyers will spend a lot of time talking about the difference between interest-based negotiation and positional negotiation. And I always find that this is the fundamental paradigm shift for a client to adopt, understand, and just change their entire way of thinking. And we're not always successful. Sometimes we never really truly get out of what we're defining as a positional experience or a positional negotiation. But I always explain the difference to my clients or to anybody who's going to bother to listen to me talk, that when we're talking about interests, we're really talking about, why is way too simple a question, but it's the question. So what is motivating? What in your gut is making you feel that you need the thing or the arrangement or the whatever it is? There's something motivating you that has nothing to do with the money or the physical, presence of the house or whatever it is that we're talking about. But there's there's a motivation there. And that's sorry, go ahead.
You mentioned like besides the money, and I know that some people will want to say, no, but the money is the why.
They might. And I always, one of the things I learned and through the training and through the course that we've done is, okay, sure, the money is the why, but why is the money the why?
Right.
We have to go layers by layers by layers, right? I mean, I want the money. What do you mean? What do you mean? What's my motivation? It's like, well, I mean, maybe it's a little bit glib or it's too simple, but what are you going to use the money for? What's the money going to do for you? Are you just going to keep it? Or is that your retirement fund? Or is that your financial security? Or is that your, right? Or do you just want to put the hurt on the other guy? It's possible. But yeah, digging through the layers of that motivation, this is what I want. Well, what does it get for you? How is this making your life better? How is this changing your children's life? Whatever that is, getting them to identify the reasons, those gut level motivators, as being what we're really talking about, as opposed to the end result. So just exploring that, it's a chance to understand the client, right? That's always that's an interesting part of the process is, having permission to be very curious and find out, what it is that really matters to people.
I don't think you can overstate the importance of getting to the interest, because as a lawyer who does a lot of negotiation and family matters, and I'm not involved in big C collaborative law, it just doesn't really happen outside of that. It does not really happen. Even though I'm aware of interest-based negotiation and I think it's the best way, the negotiation that I engage in tends to be if it addresses those interests at all, it tends to be just scratching the surface, like very kind of shallow, and you're just trying to help somebody kind of get this done. You're not really going through that process of exploring deeply the motivations behind everything, which is what I think you need to do if you're going to come up with a solution that addresses all those underlying issues. So, I mean, Heather is always trying to convert me to Big C collaborative law. I have yet to commit to taking any courses or getting that designation, but that's one thing I see just right away from what you've said so far, that people may not fully appreciate how different that is from the usual negotiation process. And I feel like it's just really hard to get there if you're not in the collaborative process, because both lawyers have to be like committed to doing that and then do it.
Yeah. It's interesting to hear you say that, Evan. Just, the perspective of someone who doesn't practice the Big C collaborative or formal collaborative, that conclusion I think is quite fascinating. And I've come to that conclusion myself, that if we don't have that, maybe what the big question is, what's the difference between a regular negotiation and a Big C collaborative negotiation? Is it the threat of court, or is it something else in the process? I think on its basic level, it's the threat of court. And what I've found is, I mean, it doesn't always happen, but it often does in a negotiation that's intended to be an interest-based negotiation. If we don't have that commitment not to use the court system, it's very, very easy just to fall back into the positional negotiation, which is, we have the authority, we have the facts, you're wrong if you don't agree with us. And if you don't give us what we demand, we'll go to court and we'll win because you're wrong.
Right. Because we can just go there and get a better outcome.
Yes.
Yeah. And then you just do, an economic analysis, and you're like, well, risk, cost, how is it going to look? Is it worth it? Aren't you tired?
Exactly, right. It'll cost this much to bring the application, and all the steps that are involved. And this is this is the difference in our our end result positions. We're going to spend more going to court, or we're going to spend less going to court than what you might get on your average day. And so let's just make that decision based on that. And it's effective. We resolve files all the time that way. I think our profession is largely built on that, and it's not wrong, but it leaves that deeper underlying, motivation on the table in order, like, of the things that we can talk about, of the things that we can explore to get to a result that makes everybody okay.
Yeah, I think like the result may vary or may not vary, but that's not really the point, right? Like you may come to the exact same result, but the way that you get there might be the important part. In fact, what you said before we started filming was that you think process is probably the most important thing. Can you just talk about that? What you mean by that?
Yeah. We were going there at the same time, I think. So you're right. The result might be the same. The dollars in the bank account might be the same, or they might be, nominally different by the end. The timeline might be similar, or might be drastically different. All of these things don't really make or break what it is, but how that process works, I think, really fundamentally does affect people in terms of how satisfied are they with the result. So I do believe that the process is more important than the result, and a huge part of that is just how we have two parents of children. Obviously, that was a little redundant of me to say, but we have two parents taking care of their children, and they need to work together for the next 15 years, and then they still have life together whenever they go through the milestones. So if we set them up to fight tooth and nail and belittle each other, which frankly most affidavits in the litigation system are, like I said, I'm biased. How does that play out for their children, for their own mental health, for their satisfaction as they go through the next 4 decades together? That's why I believe the process is fundamental. If we can teach them or give them a pattern of relating through their disagreements, of which they'll likely have many, that doesn't just involve, well, I'm going to bash you on the head if you don't give me what I want, then I think we've done them a greater service than just giving them good legal advice. And if we can, maybe we should. Sort of kind of what I think a little bit about.
Yeah, I really agree, Jeff. I think it gives people an opportunity to speak to what their motivations and their interests are, and to be heard and felt heard. And I don't think that can be understated in a process. And sometimes it doesn't feel that way coming out of litigation. A judge might make their decision and make very sparing reference to the facts that they considered. And I don't know what Evan and Jeff, your experience in litigation had been, but often you come out of the courtroom and they'd say, but what about this? Or what about that was in the affidavit, or that the judge didn't, mention? And they might have had an objectively great outcome even from court, but the fact that thing that was so important to them wasn't addressed still leaves an unsatisfied feeling for people. I think that the process is really important.
And I think that identifies like almost a universal interest that people have that I don't even know that we ever talk about it, but it's simply, well, maybe it's complexity. It's that need to be understood, and need to be heard, and need to be respected. And I don't really think that a client's going to get that in front of a judge. Maybe that's way too big a blanket statement. I saw the expression there, Evan. I think I said something wrong. But
no, I don't think you said anything wrong. I think you're absolutely right. I mean, I was just thinking about Stephen R. Covey. He talks about the habit seek first to understand, then to be understood. He talks about giving people psychological air. And what he means by that is, I know I've mentioned this on this podcast before, but if you're drowning and you can't breathe, nothing else matters. You just need air. And so he talks about when there's disputes between people, that need to be heard is like needing air, and you can't deal with the other things. You can't deal with what the other person wants to say until you're heard. And so that's what I think might be, I don't know, but I think that might be what's underlying what you've experienced, Heather. And I think we've all experienced, where there's like this just feeling of not quite dirty, but just lack of satisfaction from the court process. Even when you win, as in you get everything that you're asking for, sometimes it can still feel like, unsatisfactory.
Yeah.
Maybe that's why.
You didn't have a chance to tell all of those things that are bugging you, right? And not necessarily in an accusatory way, but be able to be heard, be able to be understood, and feel like you've been listened to. I don't think it really matters what that end result is going to be. It matters, but not as much as they think.
Yeah. And I don't think that's to suggest, or I don't mean to suggest that the court's not doing a good job at making decisions according to the law. They generally are. But when they're making decisions according to the law, they are not necessarily making decisions according to using the same set of factors or interests or goals that the people bringing their questions before the court have. So there's a misalignment there. Even if there's the same outcome, it's kind of, there's that disconnection then between the criteria that are being used and considered. And then I think in collaborative law, then the law is one input that we use to guide our decisions or to help conversations, but and they have to be sort of reasonable. The outcomes have to be reasonable within the law, but I think it's really de-emphasized and it's not used as the measuring stick. It's one data point among all of the other data points that families bring to the process to evaluate options and solutions. And I think that's kind of where, at least in my opinion, where the process is more satisfying in a lot of ways.
Yeah, I really agree with you on that. The law becomes something to consider, one of the things to consider when we're making our decisions. And lots of times clients will say, yes, I understand that the law gives me this other thing, but that's not the thing that I want, right? I mean, just to backtrack slightly on, and I completely agree with you, Heather, I have no end of respect for judges and the justice system and the way that decisions are made. But I think the frustration that clients have is they're not trained as lawyers. They're not trained as judges. And the clinical approach that we need to take in order to do, just a pure lawyer job is I'm not interested in the motivation. I'm not interested in these things. I need the facts that are relevant to the test that is going to satisfy my argument before the judge, and the judge is interested in the same thing. In fact, get there faster, please, Mr. Johnson, because you're wasting my time.
Right.
We don't have time to talk about these, this really matters to my client. It's heartbreaking for a client to realize, and most of them don't, but that doesn't matter. And that's the objectiveness of the system. That's the strength of the system on some levels. That's what makes it feel not right to a client. And so when we get to put it all in context and say, well, here's our legal authority, here's our legal guidance, and this is kind of where we at least start. This is a baseline from which we can depart, and then we get to take in all of these other factors, and you can make your decision that wildly diverts from the law if you want. If you want to, as long as you understand the effect and the implications of this, you can go ahead and do so. And I think that gives that authority back to our clients, Self-determination is a powerful motivator, I think, for a lot of people. And then they hopefully will feel more at peace with that result when they participate in it, as opposed to it being handed down.
Yeah, absolutely. So maybe next I'd like to ask you a little bit about the process itself of collaborative law. So how is this process so different from what we would do with a litigation lawyer if you were taking a matter to court? What are you doing that makes it different? What does it look like?
Yeah, I think kind of everything looks different a little bit, including those first conversations of, what it is that, what are we trying to solve? What are we considering as we go about resolving these problems, right? So maybe what I'm saying is the process looks different from the very, very beginning because the party's mindset changes or needs to change if the process is going to work as it's intended to. It needs to change from that first conversation with their lawyer throughout the entire thing. So kind of put the switch tracks, what's the thing, the switch on the train tracks, pull the switch, get them moving on a completely different path right from the get-go. Practically speaking, we do all of the heavy lifting within context of conversations. So we'll gather to meet. We'll explore those underlying motivations together as a group. We'll discuss all of the facts that go into their situation, gather up all of the nitty-gritty financial details, find out about their family, find out about where they're going in the next 5 or 10 years. All of that kind of stuff is going to come right into the meeting itself, and it's not hidden. It's not secret information that we kind of hide in our back pocket to influence the other side as needed. So I think once that is adopted, we're going to be open and transparent and honest with the other side. And we're going to talk not just about the law, but about all these other foundational things. That conversation, it informs the conversation. That 4, 5, 6 way conversation. There can be a lot of people in the room in order to get to our result. So that's kind of how I see the fundamental process difference, as opposed to let's make our plan. Let's identify the strongest parts of the facts that favor the test that we're trying to meet for the law, and then let's try to convince our counterpart, with all due respect, that they're incorrect, that their position is weaker than ours. Very different kind of mindset.
Right. Yeah, I mean, I think in a litigation file, I would typically have been meeting with a client, giving them some brief legal advice, figuring out, what the strategy is, where are their weaknesses, where's the strongest things, where are we going to have problems, start building up the affidavit and the information, and then trickle that information out as needed, maybe try and hide the weaknesses as much as possible, and then culminate sometime later in a trial where all of this stuff kind of comes out, right? And the judge hears that whole story and picture and makes a decision. And I kind of feel like that funnel is tipped on its head in collaborative, where we get all the facts and the information in front of us first all together, and then look for a solution with all of that information in front of us. I don't know if you agree that that's kind of how it feels, but
I think tipping it on its head is kind of the right thought there. I mean, we gather everything right up front. We're not even talking about solutions. We're not talking about answers to the questions. We're trying to identify all the questions first and all the different things. So it's very much backwards. We don't talk about, what is our solution to this issue until we're at the very end. No client wants to hear this. But I've got a file that's been going on for, I don't know, 2 years now. And we've been having fairly regular meetings. Like I said, no client wants to know this. And now we're talking about solutions. Now we're talking about what are we going to do? How are we going to, what is support going to look like? What is spouse support going to look like? How? And okay, we've got to divide up assets. We have corporations that are involved. We've got all these things. What are we going to do with that? And this is after we've met a lot of times. We've spent many hours together, and not spinning our wheels, not arguing, not getting nowhere, but gathering up all of that background. Yeah, it is a very different approach to the surprises, or I guess they're not surprises, but then to the funnel method of litigation for sure. I guess it's a reverse funnel, isn't it? For the collaborative process, we open the funnel as wide as possible, whereas
Right. Yeah.
let it all come out in the spray at the end.
Yeah, that's so the collaborative process essentially is everyone sitting down together to talk about the family, talk about the questions that need to be answered, and then working on answers to those questions.
Yeah, I think that's about it, right? How are we going to solve our mutual concern with what our kids are going to do and how they're going to adjust to this? How are we going to solve that? Right, and that of course is going to lead into all kinds of practical questions. How are we going to, as well as we can, try not to cut off our legs for our retirement? How are we going to manage our whatever we've accumulated together in a way that we're both going to be okay? I find that a lot of times when you kind of dig in past the anger and the hurt, most people, not all, but most people still have some level of concern for their partner. They generally don't say, yeah, I would be happy if that person was in a gutter and died. They seem to think, they seem to want, when you dig in, yeah, I think they deserve to retire as well at some point. Maybe not as soon as they hope, but at some point. Right. So yeah. I forget what we're talking about.
No, but I think it just kind of illustrates something that, it probably doesn't start out that way, I would imagine, most of the time, where both people are just like, I'm really concerned about the other person and I want to make sure that they're, it probably doesn't always start out like that. That might be something you have to dig down before you actually get there. And I think that's just a contrast with, we need everything right now. We're like we need everything immediately, everything, right? Domino's kind of started the trend. I mean, they didn't start it, but 30 minutes or it's free was their thing, right? And now it's like, we don't even call each other anymore. It's by text. And if someone doesn't answer you right away, it's like, we're upset about it. And it's all about instant gratification. And I find that with people who are getting divorced too, they want to be divorced yesterday.
Yeah.
And, I suppose that's possible for some situations, but the vast majority, if you've been living with each other and you've been married for any period of time, guess what? Your lives are totally intertwined, and taking a chainsaw and just cutting it down the middle is not usually an effective way to deal with that. Yeah,
absolutely. It leaves a lot, to be desired in terms of potential for any kind of civility going forward, I guess. But yeah, absolutely. I think the desire for speedy resolution is absolutely present, and that's part of it's part of the paradigm shift. It's going to happen no matter what. If there's any level of complexity to the matter, right? Because in litigation, it's going to take who knows how long. In collaborative law, it's not as fast as clients want, but it's sometimes faster, despite my previous example.
Oh, as if there's no litigation files that are 2 years old.
Yeah, I know.
Right.
So,
Yeah.
So I mean, yeah, getting the entire thing to slow down. And that's kind of one of the things about collaborative law. It feels like we start very slow. We can maybe talk about how we start off a file. And I think clients are like, oh my goodness, what are we doing here? This is going to be a total waste of time. I think that's their knee-jerk emotional reaction to when we actually finally sit down. Or in short order after we discussed for the first time with our clients to sit down. But the mental paradigm shift is, yeah, we're going to take some time to sort out something that's this complicated for you. It doesn't seem complicated at the time. Just give me everything I want and they can go away. But it really actually is. So, but getting them to slow down enough so that we can move quickly. Kind of is that an oxymoron? I think it is. But,
take paradox. Yeah, take the time so that you can go quickly. There's something in there. There's some sort of catchphrase in there.
There's a military saying that slow is smooth, smooth is fast.
There you go. Oh, there you see, that works well. I like that. I'm gonna adopt that and writing it down right now.
That's what they preach to you when we're learning like weapons drills. Like weapons drills, they have to learn if you're going to go be actually fighting in war. So like how quickly you can change your magazine and stuff like that is slow is smooth, smooth is fast. If you try to rush it.
Yeah, no, that's a wise saying there. I did just write it down because I want to make sure I put that in my client preparation materials, because it's absolutely true, right? I think the same thing applies to a litigation file, right? But when we actually gather enough information at the beginning, then we have a much more complete idea, which leads to that smoothness and leads to less backtracking, less changing of our minds, and all that kind of stuff. In collaborative law, we just make that a real focus. We're going to spend all this time gathering, front loading the entire thing, the entire question, with all of these non-results style inquiries and meetings that we didn't decide anything today. No, we didn't, because we're getting it all together, and then we can move quickly, right?
Yeah, I mean, it makes good sense that preparation is usually the most difficult part of anything. I used to have a tiling business, and the actual laying the tile down was the easiest. That was the fastest. The hardest was making sure the surface was ready to put the tile on, and making sure that everything is marked out and cutting the tiles. All that took a long time. Actually slapping the tiles down was the fastest.
Yeah, the easy part. Yeah, for sure.
And
it might also be important to point out the background of collaborative law, because we've never actually talked about where this idea came from, the word collaborative. And lawyers have been fighting for a long, long time across the world to make this process available to people. And for the average person, they might be listening to this episode thinking, a couple of Edmonton lawyers decided they wanted to work together and they called it collaborative. But it does have a meatier background than that. And I'm wondering if people ask you, you lawyers, about the background of this process and why they should trust it.
That's a good question. Thank you for proposing such a difficult question, Kim.
It's okay. Heather can take this one.
Heather, over to you. I think actually the roots of it are actually remarkably similar to what you just suggested, Kim. That there's a couple lawyers in the town who said, you know what, I think we could do this in a better way. I'm pretty tired of the, whatever Friday evening flaming mail. I don't know if they had email at the time. They probably did. It was origins are early 2000s, right? 2000, 2001. So email was a thing, right?
Yes, yeah.
We're not that old yet. but that decision, you know what, we can do this with just, let's not go to court. Let's do this, not that. And I don't, similar to what I said before, I don't know if I don't know if that was a lawyer interest where the lawyer said, my professional life can't take this anymore, which is entirely plausible in my mind. Or if it was for the client. And I think it's one of those happy coincidences where it happens to work better for both, right? It's good for the lawyer not to be knowing that there's probably a flaming turd in the inbox at the end of the day on Friday. Something that's going to explode dramatically over the weekend. It's your child's birthday and your anniversary and it's a holiday and all that kind of stuff. But it also serves the client because they're embarking on this wonderful process, this thing that's going to resolve. It's going to change their process. It's going to set them up for hopefully a healthier transition. So I can't remember who the counterpart was, but the origins of the process was a man named Stu Webb. And the idea was so simple and revolutionary that it spawned his own, he wrote a book and then started this collaborative group, which grew to an international movement. And some clients care, some people don't. That there's an international aspect of this, International Association of Collaborative Professionals. It's a mouthful to say. I don't think there's a national presence, but there's a provincial presence or a collaborative. What is it called?
The ACFPE. That's Edmonton and Alberta. I know I'm terrible with acronyms.
Letters from the alphabet.
Yeah. JLK.
Yeah, we have the Edmonton version, the Association of Collaborative Family Professionals of Edmonton,
Yeah.
and then we have the provincial one, which of course is escaping my tiny little brain right now. So, but it is a highly organized group of bodies, I guess, and we all adhere to the same ethical code, which is on top of our regular lawyer code, our lawyer obligations. So it introduces a whole new set to interlay over top. Is that interlay? To put over top of our existing ethical obligations, and also an understanding of just what does that mean? What does it mean to be a collaborative professional? Which gets into, some of it is guidance on how to resolve the problems we talk about in an interest-based way and all that kind of stuff. But all of this this theory on what is the best way to work together in a collaborative process, a non-adversarial, non-litigious process. Most of the theory developed from that international cooperation of professionals. We have all kinds of great authorities great resources from across the world that we draw on to make it better, I guess. Hopefully we're better.
So I have a few questions, but before I ask them, Kim, did that answer your urging for your question about the background?
Yeah, I think, I think my point was that it wasn't just something that was tossed together. This is a pretty well-oiled machine that a lot of people take a lot of pride in learning and being a part of.
A process that's been used successfully thousands, if not tens of thousands of times, I'm sure.
Oh yeah, it's used around the world and to largely, often at least successful, often successful. And I think part of it as well, I mean, it did evolve. It's only 21 years old or so. It has to have evolved over the last 2 decades, and it will continue to evolve, right? It's not.
Yeah, we had Paulette de Kelver on talking about. Well, did we talk about when she was on last about how it applies to civil sphere? So it's expanded from family law to civil as well.
Yeah, to me that's really exciting. I love to see that. in the civil, I mean, there's some very natural places for it to exist in the civil litigation world. But to me, it's just exciting to see. It's a paradigm shift for problem solvers. Right?
Okay, so my two questions, Jeff. Question number one, even though you've got this higher code of conduct, what if you're in the process and the lawyer on the other side and their client on the other side are just not doing it well? They're not doing what they're supposed to do. They're kind of sewering everything. Does that happen? And if so, how do you deal with that?
Yes, that happens. I think that is the most difficult scenario that we encounter. And unfortunately, sometimes it's fatal to the process. So the nuclear option, which sometimes is the only one, is everybody backs out, retains new lawyers, retains, everybody retains new lawyers and essentially starts over again, which is, okay, we have no possible way to move forward. We've got to start over. And that's frankly, that's kind of heartbreaking when that's the only option. And I describe that aspect of it to my clients as that's the double-edged sword of collaborative law. That potential that we're going to get to a spot where there is no forward. It's impossible. That may happen. And there's a real consequence there. Financial, time, emotional energy, that's a massive consequence. But at the same time, that consequence is enough, hopefully, to motivate everybody to work harder, to get back to the table, identify what the issues are, identify where we're breaking down here. Why can we not communicate here, and keep it going? Ideally, dealing with, or addressing that problem of, okay, yeah, everything's just getting sewered, we can't move forward. Ideally, there's enough professional respect to have an open conversation with the other lawyer. That's extremely difficult. I don't think I've ever had to do that in a way that, I think that you're causing problems here. And I haven't had a lawyer say that to me yet, but it could be coming. But that would be the best case scenario, right? We're solving the problem collaboratively. We have an impasse. We're going to treat that just like we can't agree over the matrimonial home, or we can't agree on, whatever, parenting time. Approach this impasse the same way. But yes.
If I can,
yeah,
sorry. I was just going to add in there that one of the hallmarks of the process is that you'll have these 4-way meetings. So it'll be, or 5-way meetings with your financial neutral land, or a psychologist, a mental health specialist that'll come in. You'll have those meetings as a group, but then each lawyer is going to debrief with their client, but the lawyers are also going to debrief with one another and with the other professionals in the team. And that's where we're meant to be troubleshooting those issues that are coming up in the process. So if it's a client that's not being forthcoming, or is maybe having trouble with making that paradigm shift and expressing their positions in a more interest-based way, if they just keep coming and saying, I need 60 grand, and they're having trouble expressing why or getting at those interests, what can we do as the professionals, as the guides of that process, to help them bring those interests to the table? So there are feedback loops and mechanisms in the process to help address those kinds of problems. There's also a participation agreement that are basically the rules of engagement for the process. So everybody agrees to be respectful, to have an open mind, to come prepared to discuss the issues, to provide information that's asked of them. And sometimes, I don't know, Jeff, if you've done this before, but sometimes we've gone back to that document then and said, okay, we all made these commitments at the beginning. Are there things that we need to freshen ourselves up with here in the process so that we can keep going forward in a productive way and using our time wisely and getting to solutions? If it's a lawyer in the process, that is a little more difficult, and it can be a little more difficult. I mean, I think pie in the sky, best case scenario, we're all there because we all want to become increasingly better at our jobs with every file, and that we're seeking feedback from the other lawyer as a standard practice. What went well? What do you think I could have done better? How did you feel when, this happened or that happened? And having an open conversation. I know I don't always say the right thing at the right time or the right way, or sometimes you're surprised at someone's reaction about something. You hit a nerve that you didn't know you were going to. So part of that dialogue is theoretically part of the process and is there to catch those things. But sometimes you just can't get through that logjam. And I think Jeff is absolutely right. Sometimes it is just fatal and you can't get over some of those problems. But theoretically, there are tools there.
Yeah, absolutely. I mean, and that ability to bring in, it requires some openness still on everybody's part, but the ability to bring in a mental health professional or a financial expert to decode, the confusing part of whatever analysis we're doing, that the other tools that we have, and absolutely the debrief between lawyers, that the open, transparent communication between counsel, which is also, I think, a unique aspect of the collaborative process. It's not a normal part of a litigation file, I don't think, to discuss, my client's really being difficult here. Like, that's not really something you're going to pick up the phone and talk to your litigation counterpart about. So yeah, there's far more tools that have developed over time that let us get around those things. That's a good reminder there as well.
Mm-hmm.
Okay, so I still have my other question, but this reminded me of another question that I had as well. So I still have two questions. And the debriefing part especially. So we have a duty of confidentiality to our clients. And I know that that's different in the collaborative process. Can you just talk a little bit about how it's different and what the real impact is?
Sure, yeah. In the participation agreement, so baked into the entire principle of the process, is essentially the client giving permission to their lawyer to talk openly to the other lawyer about anything that's arising, factual, emotional, whatever it is. So the client gives express consent to share what would otherwise be confidential information. Now, we do absolutely have our mandate, if that's the right way to call it, is we have our code of conduct from the Law Society that says we will keep our clients' information confidential. So the waiver is essential, but the client also has the authority at any time to revoke that waiver, and that's coming from the Law Society. That's the deeper, more, I don't know if it's more fundamental, but that's our legal ethics, a profound principle of the legal ethics. So client can at some point say, you can't tell the other lawyer this information. And that leads us to the difficult conundrum of, is this information that is vital to the process? Or is it, your dinner party schedule in 2 weeks that you don't want them to know about for some reason? So it leads us to that question, what is it that we're keeping confidential? If it's the Cayman Islands bank account with $5 million in it, well, if you won't allow me to disclose that to the other lawyer, I'm simply going to have to withdraw. So I guess that's the nuclear. I always go to the nuclear option. I don't know why. For a guy who says that, I don't really go there. I guess I go there. So sometimes that revocation, is that a word, of the waiver on confidentiality, that can derail the whole thing, right? And that's where conversations with a client, this whether you're in collaborative or litigation, that Cayman Island bank account is going to come out. It needs to. And could be in either situation. I can't act anymore if you're not going to allow that to be disclosed. But client has final say, and if they say you can't disclose them, you can't disclose. And that just might lead us to those difficult maneuvers just professionally. Does that answer your question?
Yeah, it does. Yeah. And I think it's kind of linked to the mindset, right? Like of the paradigm shift that you keep talking about in collaborative versus not collaborative. Because if you're not in the collaborative process, then you're looking for, there's strategic advantages that you may have that if everyone knew some fact would disappear or something like that. So in collaborative, you don't want something like that.
Yeah, often I find that the type of information that we're sharing between counsel, it's not usually some juicy fact that's going to change the breakdown of property. It's usually my client is really struggling with this because partner on the other side looked at them sideways and they felt offended. And I don't mean this to sound glib, right? I mean, there's a barrier that came into the room, and being aware of it is going to help us avoid it or address it the next time.
Right.
Yeah.
Those are usually the kinds of lawyer communications we're having, as opposed to guess what my client told me.
It's not like my client's a total jerk.
No.
Yeah.
Mike.
Yeah.
I hate my client.
That would be a conversation to have.
Yeah. It's kind of, again, one of those flip sides of litigating. We're not strategizing, but we're planning, right, as well in those meetings. So spousal support is sort of a notoriously difficult conversation to have. So if Jeff and I had a file, we might get on the phone with one another before that next meeting, and we know spousal support is going to be the next conversation, and we'll come up with a plan together. So how do you think we should present this to the clients? Like, what's going to be a way that's understandable to them? Like, it's going to address their needs. Is this going to, if we do this first, is this going to upset one of the parties? Is it going to put them off? Is it going to be overwhelming? So it's that kind of conversation that we're having. Very rarely is it, like Jeff said, some really relevant fact or salient like detail. It's more big picture kind of planning that we're doing together in those meetings.
Yeah.
So my last question is, this sounds expensive. What's the cost? And I just want to preface that with, if you're listening to this or watching this and you have that question in your mind and you're dreading the answer, I think it's also important to ask, well, what's the cost of not doing it?
Yeah, I think that's absolutely the relevant counter question, right? I mean, yeah, it's the dreaded cost question. And it shouldn't be dreaded because it's absolutely relevant to every client's situation. But it is a really, really difficult one to answer because we generally don't know. I think that the idea of being able to fix a price is fascinating, and perhaps it can work in some situations. There's going to be situations though where it's just a whole deck of wild cards, and you don't know. Apart from what's going to happen, in that first meeting, you don't know what's going to happen after that. And is this going to take 2 months, or is this going to take 2 years, or somewhere in between? So I always tell my clients, because they always want to know, I've had these things resolve in a month in the collaborative process, and it costs less than $5,000. I've had them go on for 4 years, and you don't want to know how much it cost. Just, you don't. You don't want to know. A rough guideline, which I don't really want to say this, for a client, I think, to recognize is that each meeting is probably going to cost them in the range of around $2,000 probably. But we're going to move, and we're now we're just selling things. So we're going to get things done. The alternative, yeah. What's the alternative in litigation? What does it look like? There's always going to be those files that settle right away. And yep, it's the same in collaborative. You might have one letter over where you send the draft agreement over and your counterpart counsel says, that's fine. I have no problem with this. Or, we need to make an adjustment here, and you have a quick chat and say, yeah, that's fine. Okay. We're done. No problem. And we're still in that less than $5,000 range. But you also have the ones where there's going to be the interim applications and the examinations on the affidavits. And there's going to be, I don't know all the different steps that
expert reports and valuations and
or even just what is that interim application for spousal support? What is that going to run you? My prediction, since I don't do them very much, is that's probably going to cost you in the realm of $10,000 to $20,000, probably. I don't know if that sounds way out there, but it's going to be something that puts a dent in your wallet, and it's just one step.
Yeah, I think. Thank you. I think that's a good answer. I think if you compare it to the court process, which is what you inevitably compare it to, because you're opting out of the court process for the duration. Unless you're going to do that court process on your own without a lawyer, you're looking at quite an expensive situation. If you avoid all the interim applications and you just go for a trial, then might only be $20,000. But if it's a really complicated matter and there's pressing issues as well, then you're going to have interim applications, and there's going to be all these other steps that you alluded to, Jeff, and then you'll end up at a trial. And I think it's not unheard of for people to be spending $20,000 to $80,000 or more, depending on how complicated their situation is on that litigation process.
Yeah, I've heard some experienced litigators talk about just how much a trial costs per day. I don't think I want to quote the number because I can't recall, but it was in the 5 figures.
It's not low. It's not a low number.
And so a 5-day trial, a 3-day trial, a 2-week trial, that can get pretty devastating. But I mean, I don't think it's a reliable rule to say that collaborative law is always going to be cheaper than litigation. There's some hope there that it might be, but really the major difference in my mind isn't the cost. There may be on average a collaborative file costs less, but I don't even feel.
Well, no, Jeff, because you're just thinking cost in the terms of dollars, but there's other costs.
Absolutely.
I think if price is equal, which I mean, maybe it is, right? Litigation is expensive, and collaborative law is also expensive. And so some might be cheaper. Like if you could somehow perform the scientific experiment, which is impossible, but let's say you could, where, you take the exact same set of facts through each process and see which one's cheaper or more expensive, then maybe we could actually figure that out, but we can't. And I don't know of any statistics that compare the two, but if the cost is somewhat equal, what would you rather do?
Yeah.
Go to court and not be able to say anything, because unless you're taking the stand in your trial, otherwise it's your lawyer doing all the talking, and a judge who's going to hear it for a couple of days or a few hours or 20 minutes in the case of one of those interim applications, and then make a decision that's binding on you, that is the law for you. Or would you like to have a process where you get to participate and you get to say everything that you wanted to say and feel heard by everybody?
Yeah, 100%. I think the non-financial cost is just as relevant as the financial cost, or more sometimes. And you've just highlighted that the process is the key, right? So it sounds like you're ready to join, Evan.
Yeah, I would say so. I think that's correct. Yeah.
Not quite yet, Jeff.
Yeah, absolutely. There's a lot more than just the result. There's a lot more than the financial cost at play here, and it's easy to lose sight of that in the heat when you're struggling for the psychological error, as you said before, right? When you can't breathe, you can't think about all those different things. Just looking for the quickest way to whatever it is, and that the knee jerk is litigation's the only way.
I think one of the challenges we really face with this is that question of access to justice, because it's not going to be for everyone. Not everyone's going to be able to afford to do collaborative law. That's just a fact. Mm-hmm. And some people are then just left to try and navigate, because they're not going to be able to afford to have a lawyer represent them to go to a trial either. So then they're left on their own to try and navigate this court process, which can be quite complicated. And it's also possible that the other person manages to have a lawyer, and then you have, in a situation where you're going to a trial or something like that, that's a pretty significant imbalance.
Yeah, absolutely. And I think that's ideally, probably idealistically, it's this type of process, a collaborative process, or something that looks very similar to it, is part of that answer to how do we access justice for the average person. That's maybe where the innovation still lies. Because it's absolutely a fundamental problem. If we can't afford to talk about it, if we can't afford to get to that solution, then maybe you end up settling for something that you really don't want, and that leads to all kinds of problems down the road. So,
yeah, I think I've said this before on the podcast too, is that the other people don't need to know you're doing interest-based negotiation. You can, you as a lawyer or you as a party can learn about it and use it, even if someone else doesn't know or isn't reciprocating. It's not always going to be as successful as in a collaborative atmosphere where you're both doing it deliberately. But if you're finding out from your client what's important to them and understanding why one resolution or another resolution might or might not be acceptable to them, then that's helping them out, and that's being more efficient and saving them money in a litigation or non-litigation atmosphere. Or if you're a self-represented litigant and you learn a little bit about interest-based negotiation and figure out what's important to you or what you think might be important to the other person, then you might be able to disrupt that logjam yourself, right? If you can kind of get down to those things. So is it as effective as both people being involved? No, probably not. But, you can do a little bit of that heavy lifting and make things run more efficiently. I hope. That's my dream anyway.
I think you're right, Heather. I mean, it's not going to be perfect, because look how difficult it can be when both people agree to do it. Sometimes it can be difficult. Yeah. But that's how I met Catherine Spafford. We were on the opposite sides of a file, and I practiced interest-based negotiation at a four-way, and I don't know that it was because of my skill or anything like that, but her client did like a 180 degree on the issue was parenting, and I really think it was just because it may be a number of factors, but I think it helped that she felt heard. Now, we didn't try to come in there and convince her she's got to change the parenting arrangement. We just asked. I just came in and asked her questions and tried to understand her fears and her concerns about the parenting situation. And we didn't even finish. And she's like, "Yeah, I'm okay with changing it to this." Yeah. And so it can happen. It doesn't happen very often, but you should become a judge, Heather, and then you could run your courtroom that way.
No, that's absolutely right, though, Evan. I mean, it doesn't belong. It's not proprietary to this process, right? I mean, it is a powerful way to deal with people, and they don't expect it. Clients don't expect to be, especially clients on the other side of a file, they don't expect to be treated like that.
I know. They think the other lawyer is always going to be a jerk, because most of the time they are, especially if it's like questioning or something like that, right? And
Mhm.
Yeah.
Yeah. Well, and they're meant, not that they're meant to be a jerk, but in the adversarial process, that's part of the role, right? Is to go in and challenge evidence and,
Right.
and yeah, narrow down the issues, all of that stuff. But that's not necessarily the best or most peacemaking way to a resolution for
Right.
families.
Right. Right.
The things that they're asking about don't even play into the law.
Mhm.
They're not relevant
Mhm.
Mhm.
a legal analysis point of view, but they're absolutely relevant to a resolution point of view. So
Yeah.
Well, Kim, you have anything you want to say? Any other questions that you have?
I have one observation and one, I know my role here is to kind of point out legal slang that pops up in our conversations. So after my observation, I'll let somebody kind of give the skinny on what Big C collaborative law is. But my observation on collaborative lawyers is from being allowed to be in the room with a whole pile of them and listening to them talk and sort through things. And I think the value, there's a really important value that also isn't talked about, and that's the skill set of people who are practicing this day in and day out. It takes a lot of time to get good at conversations and keeping the energy in the room the way you want it to be to help resolve things. And I've been embarrassed on numerous occasions where I can tell my energy isn't matching the crowd. They're very calm. They can sit on something. They can sit in a moment and give space to a thought. And I think it's just so valuable to have people who are trained in this and practicing this all the time to help work through some of these issues. So that's my observation fly on the wall with collaborative lawyers. They're important people who dedicate their time to something that does change lives. So that's my bit.
I'm just trying to picture Kim letting the mad dog come out. Well, like everyone else is calm and Kim's just losing it. Okay. The Big C collaborative versus small C collaborative is just a way we kind of talk about Big C being somebody who has done all the training, and I think you guys are accredited, right? Some kind of accreditation process. That's a Big C collaborative process, is when you're doing it officially through two collaborative law lawyers and with collaborative professionals like Kim. Small C is you're just not in that official collaborative law process for whatever reason, but you're still trying to work collaboratively to come to a resolution, maybe using some of the same skills and tools.
Yeah.
Am I right?
Go ahead, Jeff. Yeah.
I was just going to say, generally speaking, when we talk about the small C collaborative process, what I expect is that we have not taken court off the table. So, and that is what makes the fundamental difference. I think one of the things that makes the difference. So yes, absolutely, there's interest-based negotiation, hopefully in every negotiation, every small C negotiation. But if we have refused to enter the Big C process, it's likely because we don't want to take court off the table.
A lot of C's in there.
Yeah, I was going to say it's because it's Big C if you've signed the participation agreement is what I would say. But that's exactly what that is that Jeff has referred to, is that it is that agreement signed by both lawyers and clients and any of the supporting professionals that acknowledges that they will not go to court. So I think that's the big difference.
Yeah.
Yeah. The philosophical approach is the same. Mm-hmm.
Okay, Heather, any other Big C or small C collaborative contract court comments?
No, I just think, one really important piece I think that Jeff said before is that I don't think any of these processes is ever going to go as fast maybe or as efficiently as most as most people would want them to. But the process is important. And I think, as Kim alluded to, tens of thousands of families have been through it. It is a trustworthy process that works most of the time. So just to kind of hang in there and let it be slow so that it's smooth. Yeah.
Okay, Jeff, anything that you wanted to cover that we didn't cover?
No, I don't believe so. I think that we've talked about most things quite thoroughly.
Didn't you say in your email something like, I don't think we're going to last for like 40 minutes?
I guess we did. So
yeah, I think we're at like an hour 15, maybe an hour 20. So you had a lot more to say than you thought you did.
Oh, sorry.
No, I really appreciate it. I appreciate you coming on. And, you know, I know I speak for Heather and Kim as well, that we really appreciate it. And that it's been really good to hear your perspective and to learn more about the collaborative process, maybe inch me a little bit closer to taking those courses and joining the field.
Yeah, I hope you do. So I appreciate very much the invite. It's always good to nerd out about this stuff a little bit and have a good conversation about hopefully how we're helping clients with all that.
I feel like in some way this podcast is really geared around Kim convincing me to get different types of insurance, Heather convincing me to become a collaborative law lawyer. We're getting there.
That's right. Basically the point. Basically the point.
Out of love, out of nothing but love, not no other motive.
No other motive. All right. Well, thanks for coming on, Jeff. This has been another episode of Access to Justice. We'll see you next time.
Any information in this video is general information only and is not, nor is it intended to be, legal advice. Watching this video does not create a lawyer-client relationship. You should always seek the advice of a lawyer or other qualified professional for advice regarding your individual situation. While we take care to ensure that the information contained in this video is accurate and up to date, we make no warranties or representations as to the suitability, completeness, or accuracy of the information contained in this video. Any reliance you place on the information is at your own risk. Kahane Law Office, Merrick Law, Heather Malarick Professional Corporation, Evan Clark Professional Corporation, Evan Clark, Heather Malarick, and any guests will not be responsible nor liable in any way for any content, including but not limited to any errors or omissions in the content, or for any loss or damage of any kind incurred as a result of any content communicated in this video, whether by Evan Clark, Heather Malarick, or by a third party. Kim McDonald is a financial advisor with Raymond James Limited. Information provided is not a solicitation, and although obtained from sources considered reliable, is not guaranteed. The view and opinions contained in this media are those of Kim McDonald, not Raymond James Limited. Securities-related products and services are offered through Raymond James Limited, member Canadian Investor Protection Fund. Insurance products and services are offered through Raymond James Financial Planning Limited, which is not a member Canadian Investor Protection Fund. Raymond James advisors are not tax advisors, and we recommend that clients seek independent advice from a professional advisor on tax-related matters. Insurance products and services are offered through Raymond James Financial Planning Limited, RJFP, a subsidiary of Raymond James Limited, which is not a member Canadian Investor Protection Fund. When providing life insurance products, financial advisors are acting as insurance representatives of RJFP.
Darkness of the dales dissipates, declines, because of he who turns